This is IAQradio, Indoor Air Quality Radio, the voice of the indoor air quality industry, with your hosts, Radio Joe Hughes and the Z-Man, Cliff Zlotnick. And now, Radio Joe Hughes.
Good day and welcome to IAQ Radio Plus. This week is episode number 553. Joining us live from the Florida, the site of the AOB town hall held last night. We've got the Restoration Global Watchdog, Pete Consigli, who's going to be our co-host today. And our guests are Harvey Cohen, Peter Crosa, John Lapotaire, David Popper, and we're hoping Justin Peterson of David Popper's law firm will also be joining us as well. Check out our Facebook page, our YouTube. Give us a like. You can also download our podcast and link to our YouTube videos. And you can also get continuing education credits right on the IAQradio.com website. Before we get started, let's thank our platinum sponsor.
IAQ Radio Platinum sponsor is John Don Products, where restoration and abatement contractors shop. Visit them at jondon.com. That's JONDON.com.
I also want to thank our gold sponsors, Particles Plus, Healthy Indoors Magazine, Gray Wolf Sensing Solutions, and AEML Inc. Laboratory. And of course, our association sponsors, CIRI, the Cleaning Industry Research Institute, the Indoor Air Quality Association, and the Restoration Industry Association. Okay, the Z-Man's on the road this week, so I'm going to handle the trivia question. First, we want to, it was a close one last week. They had to look at the timestamp on the emails, and Vic Cafaro of Virginia was the first to name Mr. Yuck as the trademarked image created by the UPMC Children's Hospital in 1971, widely employed in the U.S. in the labeling of substances that are poisonous if ingested. This week's IAQ Radio Trivia question, Friday, July 12th, 2019, has been sponsored by Ideas, the solution chemistry company, providing unique solutions to odor removal, surface cleaning, and decontamination problem. Today's trivia question is, who was Florida's first director of the Office of Insurance Regulation? So the first director of the Office of Insurance Regulation. All right, so our guests today are Harvey Cohen, Esquire, the founding partner of Orlando-based Cohen Law Group, Orlando-based attorney David Popper, who specializes in contract law, environmental consultant and expert witness John Lapotaire, friend of the show, and Peter Crosa, the former president of the NAIIA, the Trade Association for the Independent Insurance Adjusters. Also joining us will be Justin Peterson of the David Popper's law firm in Orlando. Before we get started, let's turn it over to my co-host for today, Pete Consigli, the Restoration Global Watchdog. Pete, why don't you give the listeners a little feedback on what happened last night?
Yeah, thanks, Joe. Hello, everybody. So, listen, last night we held a town hall meeting in Deerfield Beach, Florida. Those of you that are not familiar with South Florida, that's right off the Interstate 95, about halfway between Fort Lauderdale Airport and the West Palm Beach Airport. We had a crowd, I don't know, I want to say maybe 60, 70 people or so, plus the vendors that supported it. We had Sunbelt had a table. Jay Stake, the president of IAQA, drove down from North Carolina, shared some information. You know, their convention next year is going to be in West Palm Beach in February, so it's basically right here in South Florida. And we had John Capone with the business development associates had a table here, networking, you know, with the different attendees in the area. And of course, the whole event was co-hosted by the Cohen Law Group, and one of the sponsors for the show that was mentioned in the opening credits, Ron Mazer of the AML Inc. Microbiology Laboratories. So, you know, some of the attorneys from Harvey's group were down here, and was a very lively discussion. We had the four guests today. Two of them, Harvey and John, were there live on site, and then we had a call in for Mr. Crosa and Mr. Popper, and Justin was in the office with David, and they weighed in. So each of them weighed in on the whole issue of the AOB and the legislation that just was enacted and where we go with it all now. They all had their different perspectives, two different legal perspectives, indoor environmental professional perspective, and then, of course, the perspective from the insurance adjuster. So it was lively. We had several questions, a lot of handwritten questions. We had some interaction with the audience when we kind of moved to the open mic, and everybody seemed to enjoy it. We had some nice hors d'oeuvres, and people did a lot of networking. And anyway, so today what we're going to do is we're going to kind of cover the proceedings, the high points. Joe, you're going to do all the heavy lifting and the questions and the interviewing. I'll kind of come in around to the roundup, and I'm going to spend my time taking a little notes. I guess part of the duty of taking over for Cliff is to have to do the blog. So I got to I always watch when I'm watching Cliff. He's always taking notes and writing down. So that's kind of what I'm going to be doing. So anyway, with that, Joe, I'll turn it back to you and go ahead and kick off the show. Anyway, I appreciate that. It looks like we got 20 plus callers in. I appreciate you all calling in today. I hope the information you find out is useful for you. Thank you.
All right. Thanks, Pete. Let's go around the horn, gentlemen. I'd like to get a little opening thoughts from each of you on the town hall last night, what your perspective was, what your thoughts were, but more importantly, what your contribution was. Let's start with Harvey. You were your law firm was one of the sponsors of the event. Harvey, tell us a little bit about why you did this and what's going on with the AOB. Is it dead or is it still somewhat alive?
Well, can you hear me?
Yes, sir.
Okay, I just wanted to make sure I wasn't still on mute. Hi, everybody. Yeah, no, I thought the meeting went very well. We had some great questions from the audience. Really, the purpose behind the whole meeting was to educate contractors so that they can understand and make their own decisions about if they want to use the new AOB law or not, or what are some other alternatives to the assignment of benefits if they don't want to use this new AOB law. And worked out great. The panel was great. I think everybody really added a lot to really help people. The feedback I got from the attendees was, basically that it was very helpful, and they were thankful that we all came out and put on the presentation.
All right, let's, Harvey, I'd like to follow up. Maybe I'll do it a little bit later, but I want to get your thoughts on how many contractors, or maybe let's do it right now, and then we'll bring in David on this. How many contractors in Florida, the restoration contractors? There's got to be thousands of restoration contractors. And I guess I'm curious, how many really have been taking advantage of using that AOB and having, I guess, the homeowner sign over the assignment of benefits to them. Is that a common thing in Florida? I know it's not real common here in Pennsylvania.
Yeah, it's very common here. I don't know the exact numbers or the statistics or percentages, but I do know that, many contractors use the assignment. The homeowners that we represent for hurricane claims, et cetera, are, support the use of the assignment of benefits. It helps them because they can essentially allow the contractor to bill their insurance company directly, just like a doctor does. When you go in for a doctor visit and you sign the paperwork for the assignment of benefits, it's the same thing. And then the doctor bills the insurance company directly. The assignment of benefits for contractors works the exact same way. They do the work, and they send in the bill themselves and deal and negotiate directly with the insurance company.
And let's go over to David. David, I guess.
Hey, Joe, before you do that, I can answer part of that question they asked Harvey about the numbers. The database in Florida, based on the Department of Regulations for licensed mold assessors and remediators, and remember now, most of these remediators fall into that contracted category, is somewhere between 18 and 20,000. It's a pretty large number. So that's at least a frame of reference.
Okay. Well, thank you. David, let's take it over to you for a moment. The AOB situation, first, let's give us your thoughts on your discussion and talking with some of the contractors last night and what their questions were.
There's a lot of confusion out there, but frankly, I don't think this is the end of the world at all. We're going to have a contract where people sign and the homeowner is going to be responsible for it. But if you have a relationship with the homeowner, he's going to get the homeowner to sign up with Harvey anyway. And Harvey's going to be able to pursue the insurance company with the homeowner anyway. And they're going to be able to get a letter of protection, which means that the contractor will not be in exactly the same position, but not far off. I think it's going to make contractors have to have a better relationship with their customers, which is always a good thing. Communication matters. The only problems I really see when I've litigated these things is that a contractor may not communicate for a couple of weeks for very good reasons, but the homeowner doesn't know what's going on and gets nervous. So it's going to require more hand-holding by the contractors. But if you keep that good relationship, they're going to hire Harvey. Harvey's going to be able to get the insurance proceeds. And I don't think there'll be much slip between the cup and the lip, if you would. If it does fall apart, you have a solid contract against the homeowner. You've got lien rights. And more importantly, you have contract rights too. So the contractors are going to be well protected. And yeah, it's a little more trouble. But it's not the end of the world.
Let me follow up on that, David. As I understand it, it's not so much the AOB is still alive, it's the fee shifting part of it that's not alive. Could you explain to listeners what that fee shifting is? And then if you know, or if Harvey knows, is that a Florida specific thing? Was that just Florida, or is that also available in other states?
Well, there's what makes it so powerful in Florida is we have what's called a fee shifting statute down here, which means that if you have a dispute with your own insurance company and you're forced to hire an attorney to represent you, then if you win, then the insurance company has to pay all of your attorney's fees and costs. So the same thing goes with the assignment of benefits. If you have an assignment, then you can essentially have an attorney represent you, and they only get paid if they win the case against the insurance company.
Okay. David, did you want to add anything there? And also, do you know if if there are similar laws around the other states in the country?
Well, most states have two-way streets. It used to be with the prior law, it was a one-way street. Contractors could sue. If they lose, no harm done. If they win, they get their fees paid for them. Now, if you don't prevail, and I'm going to have Justin give you the exact percentages, you might owe the insurance company's attorney's fees. So it makes you take great pause in making sure that the claim you make is well able to be proven in court, so that you can prevail, get your fees, and get the homeowner satisfied and get you paid. Justin, would you give us the percentages on that?
Justin Peterson, I'm sorry.
My son.
Oh, we don't seem to have Justin on.
Okay, come over a little bit.
Hey, there he is.
Hi.
I'm going to share a spot with you there, Justin. So what kind of numbers are we looking at?
So the way that this is set up is if you have to make basically an offer to the insurance company to try to settle the case before you're allowed to litigate. When you make that offer, if the case is not settled, you go to court. If you don't recover a certain percentage above what that offer was, then that's what dictates whether or not you're allowed to have fees or whether or not the insurance company gets theirs. And the way the law is set up is if you recover less than 25% more than what that offer was, then you end up paying the insurance company's attorney's fees. If it's between 25% and 50%, nobody gets attorney's fees. And only if you recover 50% or more above what that offer was, do you collect your attorney's fees. So essentially, you have to take the chance that you're going to take a 50% haircut on your bill in order to make a decent offer, in order to protect your right to get attorney's fees in the event you end up in litigation.
Okay, thank you. Hey, let's go over to Peter Crosa. Peter, you're an insurance adjuster and formerly the president of one of their associations. How is the insurance industry looking at this?
Okay. Well, right now, Defense Counsel is gearing up to put on all kinds of training programs for the insurance industry. I hadn't seen a lot of it promoted up until just recently. And so I can tell you that what I think is going to happen is that a lot of uninformed adjusters are going to try to hold the contract to $3,000 limit when they go out on a water loss, on a residential loss, which I don't know where that's going to end up, because it doesn't seem to me that the statute provides for what happens if you've got a substantial mitigation process.
Yeah, $3,000 doesn't sound like a whole lot in many cases, huh?
In most cases, it's not going to be appropriate. So I don't know who wrote this law, but whoever did write this law is not really familiar with the insurance industry, does not have the consumer's interest at heart. So it'll be interesting to see how this plays out. I think there's going to be a lot of litigation over this statute. Now, understand that, you've got two lawyers on the broadcast. Most claims are not litigated, and that's the space that I live in. Maybe as much as 80% of all claims are settled prior to litigation or prior to even the suit being filed. So it's worthwhile to have the litigators present and to talk about what happens when the claim goes wrong. But most of the claims are going to be handled. And my advice to the restoration industry is get to know your adjusters. It's so much better to be working on a claim with an adjuster you know. And how do you get to know adjusters? You've got to work with the industry. You've got to attend the industry meetings and be a presence. That's what all the big boys do. All the big restoration contractors spend a lot of time and treasure involved in the insurance claims industry associations for that reason.
How many associations are there, Peter? I mean,
hundreds. Yeah, you Google anywhere. I don't care if you're in Yellowknife, Saskatchewan. You Google the Yellowknife Claims Association, you'll find maybe 2 or 3 guys that get together every month to have some brewskis and talk about the business. And that's where a contractor wants to be.
Okay, thank you, Peter. Let's go over to John Lapotaire. John, you were there to give kind of the IEP, the Indoor Environmental Professional perspective. You got the hairs on a couple people's neck going up a little bit there as part of your perspective. I thought it was very interesting, made it a lot of fun. Give us your thoughts on how things went last night, and then what were some of the key takeaways you came out with?
Well, I'm with Peter. I don't see any cases that I'm involved with going to court unless I'm hired after the fact. I think the key to success in the restoration business has nothing to do with an AOB or an attorney. It has everything to do with having a good contract up front, knowing who your customer is, and continually communicating with your customer. That's why everybody that we work with never uses an AOB. I think the change in the AOB will impact this legitimate industry none at all. I don't think it will impact any of us. If we continue to do business with a solid contract, communicating with our customer and helping them communicate with the insurance company, there will not be any problems. If you document your loss and your work and you present that information appropriately to the insurance company, you will get paid. That's what I wanted to communicate last night. I see the dark side of the AOB. I see the cost to restore going through the roof with every AOB litigation case I've been in. I see the time to restore go up with every AOB litigation case that I've been in. So I wanted to communicate to the people that came to the town hall to let them know that you don't have to have an AOB to be successful. The loss of the AOB doesn't mean the loss of any of your business. It doesn't mean the loss of any of your income. Just know your customer. I'll read you what I read last night for those that weren't there. Know your client, set the expectations up front, communicate often with your client, document everything, follow the industry standards, and be ethical. That's what I tell everybody that I work with. That's how you get paid.
Let's go back to Harvey for a moment. I know, Harvey, that you may not necessarily agree with everything John's saying, but I think we're on the same page to some degree. I know David talked a lot about contracts, and David, your group develops contracts for restoration contractors in Florida. They're specific to Florida. I remember you saying it was a one-page thing, but that you could also customize that to be more than one page, obviously. Harvey, give us the side you see a little bit. You seemed last night you brought up some I don't know how to term it, some insurance sins, I guess.
I guess John brought up some some bad actors using the AOB, and I just wanted to point out that the worst actors in the whole industry are the insurance companies and how they treat homeowners. And I've been doing this for a long, long time. I've represented literally thousands of cases for first-party claims and homeowners claims, and I've seen the most, egregious acts I've ever seen from an insurance company that will literally put somebody, not give them any money, stall them out forever. I have one going on right now where there's an older gentleman in the Panhandle who's living on his living room couch because he doesn't have anywhere to go. The insurance company is refusing to pay him additional living expenses so he can move out while their repairs are being done. And they're actually not paying for any repairs either. So he has nowhere to go, and he's living in a house that's full of mold and leaking from the roof. And that's just one example of the insurance industry as a whole. So that's one of the things I brought up. But really, really we should talk more about the future, what we can do, the AOB, the new AOB law in Florida, how bad it is, and a new method or a new strategy of doing what's right. And I agree with John. The whole point of doing all this stuff is do a good job, be ethical, make your clients happy, and everything else should fall into place.
Okay, let's Pete.
Hey, Joe.
You jump back in here, Pete.
Yeah, I want to jump in for a minute. Got the camera on me? So look, it's something to make sure Harvey's not muted there, John Faith. One of the things that Harvey passed out yesterday in his handout in his packet, and I think he's been passing this out as he's been traveling around doing some of these meet and greets around the state, is a copy of the law. This is a 16-page document. Looks like it's printed on two sides, and it is the actual Florida House of Representatives law that affects this whole conversation. Harvey, is this something that we would be able to, in the PDF version, can we upload this as part of the blog with the show? Are we able to do this? Yeah,
of course.
I was going to say either that or we'd send a link. But if I can get a PDF from this from Devin or something, Joe, I'd like to, number one, I'll add this as a PDF attachment for our blog. We've done this in the past, and then that way any of the viewers or people can go in there. And then, John, looks like John's already put a link up. But anyway, the PDF will be good because they can open it, and that way they can download the PDF. That's the first thing. The second thing is on David Popper's stuff. David and Justin prepared this 3-page document, which followed all their key talking points yesterday. And it was a handout, so a lot of the attendees in the town hall were able to follow it. And he wrote it in the basic style that a lawyer learns to write a brief or a motion if they want a judge to review it. And there's 4 basic principles. My restoration lawyer buddy, Mr. Ed Cross, taught me this years ago. They call it IRAC, I-R-A-C. You first establish the issue, then you talk about the rule of law, you do an analysis and conclusion. And basically what they did is they raised the question, okay, the AOB, the fee shifting is dead essentially. That's the question, that's the issue. Then he talked about the statutes, which is equivalent to the rule of law. Then he did an analysis, asking the contractor questions. What if you do this? What if you don't do that? Some of the things have been discussed, and then put the conclusion with the recommendations. This is a very, very useful document. And I think that if we do this, which I have in a PDF, I'd like to send those out, and then I think people get a lot of benefit from those. So that was a key point I wanted to make here, but I'll turn it back to you, Joe.
Okay, let me go over to David. David, I believe it was you last night. I don't have my notes in front of me, but I think you brought up 3 key points for every contractor to try and avoid, not getting paid, doing the job properly. I know the first one was to communicate, and you said at least weekly. I have a little construction company up here, and I actually communicate with our clients daily. I mean, at the end of every day, we give them a little rundown of what we did and what kind of progress we made. There were a couple other points. I wonder if you could go over that for listeners.
We're all in business. That's the thing that's interesting. We all have, I sell legal services, you sell different contracting services. But the thing I learned a long time ago is that when somebody's in a lawsuit, it's the first thing they wake up and think about. It's the last thing they think about. It's what they think about all day. And they hang on every word the lawyer says. Well, it's the same thing when your house is a mess. You're waiting with bated breath for that contractor. What's going to happen? How's it going to, and the contractors are very busy and they think I'll call them later. But it's almost like, think back to high school when you're waiting for that special someone to call you. It seems like eternity. It may not be. But if you put yourself in that position and you communicate often with the client, so you have a relationship, that's what we do. I mean, I've been doing this for 39 years, and there's not a time I'm in the car that I'm not calling an old client or friend, keeping up with them, and there's not a time that we don't keep up with clients every single day. Why? Because they're worried about it. What is easy for me is hard for them. Just like I'd be dangerous with a hammer and a nail. I'd be waiting for what you guys say. So that's the big thing. But the contract itself is very important. A few of the critical points are we want to make sure that when you file a suit, it's got to be in the county where you know your lawyer and you know where the courthouse is. So we put in a venue provision. That way you litigate where you are. It's important to have a lawyer in your county that knows you, likes you, and wants to win for you. Because just like everybody else, we're human too, and we tend to want to help people that we want to help. The second thing is that we, in the cancellation, we put in our contract language regarding cancellation fee. I've been in front of a couple of judges and they say, you mean to tell me just because you cancel, you owe 20%? That just doesn't seem fair. So what we do in our contracts is we tell people what we're doing for that 20%. Let me read a little bit. We do significant work before actual construction begins. This includes mitigation services, inspection, measurement, researching, order materials, creating documents. When you have that in the contract and the judges get to read it, they're more understanding of what the cancellation is. In other words, I try to keep things so simple and so self-apparent, self-evident, that there is no question. In terms of pricing, we make sure that the pricing can change if we find something. I can't tell you how many roofers tell me they price a roof for, say, $15,000, then they find there's $5,000 worth of wet wood. Well, you've got to have that in the contract. In other words, as long as you tell people up front, most of the time you're not going to have that difficulty. And that's why what we've tried to do in our one-page contract is spell out most of what can go wrong and have it clear. And when you put it clear, and when you don't use legalese language, when it's language that even, I always say this funny, I said, it's language that even a judge will understand. And I don't mean that disrespectfully, but there's a lot of judges that were criminal lawyers. They don't know this stuff. So right. You assume just because he's a judge, he knows contract law. That's not necessarily so. So we dumb it down to where everybody can read it. And I think that's the most important thing. And I agree with Harvey. I mean, it's a different day, and there's going to be some insurance carriers that try to abuse this and put you in a position where you're taking a 50% haircut, and some outcomes won't be that great. But I can tell you one thing, that if an insurance company does it too often, we do have a bad faith statute. And I've litigated bad faith cases. I know Harvey has. And you know, things come around. And if things get too abusive, courts will solve the problem. We don't know a lot of what the courts are going to do yet, but things have a way of washing themselves out. But it may take 6 months or a year for that to happen, maybe a little longer.
You know, David, you mentioned that cancellation fee and spelling out why you want. I thought that was probably the most important point I picked up all night. And I'm sure a lot of the contractors there felt the same way, you know, that we've got to, you know, in Pennsylvania, you have 3 days to cancel. I don't know what it is in Florida, the homeowner.
You actually have 3 days if it's a home solicitation sale.
Okay. But these are not home solicitation sales. These are emergencies. And there was also discussion, and I don't know who brought this up last night, about the definition of, it wasn't an emergency, but the definition of urgent.
Substantial performance.
Yeah, substantial.
Of urgent.
Yeah, urgency. Yeah, what can someone jump in on that? I don't know if maybe Peter, would you tell us a little bit, what is urgency when it comes to these contracts?
Okay, can you hear me okay?
Yep.
Okay. Who knows? I mean, that is such a nebulous term. It could mean a lot of different things to different people. I think Harvey brought that up yesterday. What does urgent mean? And so it's dangerous language, and it's just going to mean we're going to litigate. But
you know something? If somebody calls you, so it's not a home solicitation, you ought to be sending an email. Thank you for your call. Thank you for your interest in us. Why? It sounds like a nice email, but it proves it's not a solicitation. If someone calls you urgently, you may want to respond with an email. Thank you for your urgent call. I understand that you really want this done now. In other words, protect yourself. It's going to be ambiguous. Clarify it as much as you can up front.
Joe,
that's a great point.
Yeah, one of the things that should be pointed out is these are changes to the AOB, not changes to how we do business on a daily basis with a regular contract. So this isn't an across-the-board hit to all contractors. This is a change to the AOB should you continue to use the AOB.
Is this a change, Harvey, to AOB for just the restoration industry, or was there also AOB for, like David mentioned, roofers, et cetera?
Well, it's for any contractors. And, you know, what's funny about that is they actually included windshield companies because it's still property damage that's covered, and the same kind of, you know, they run into the same kind of problems. But they actually did a carve out just for the windshield companies. And so it applies to anyone who does residential or commercial, any kind of construction from A to Z. So it doesn't matter what it has to do with, if it's, you know, real property and it involves an insurance claim, then if you intend to use an assignment, you have to abide by that new law. If you don't, your whole contract is void and unenforceable.
Okay. Gentlemen, I've got to stop here and thank our sponsors for halftime. When we come back, Pete, I want to turn it over to you to start the second half.
Okay, good enough, Joe.
IAQradio Platinum sponsor is John Don Products, where restoration and abatement contractors shop. Visit them at jondon.com. That's JONDON.com. Gold sponsors are Particles Plus Engineers and Manufacturers of feature-rich particle counters and air quality monitoring instrumentation. Learn more at particlesplus.com. Count on us. Healthy Indoors Magazine, a free online digital magazine for industry professionals and consumers. Subscriptions available at healthyindoors.com. And AEML Laboratories, free FedEx shipping, great pricing, same-day results, and never a rush fee. Learn more at AEMLinc.com. Gray Wolf Sensing Solutions, who use advanced sensor software technology and embedded computers to provide superior environmental test instrumentation. Visit them at wolfsense.com. Association sponsors are the Indoor Air Quality Association, a multidisciplinary organization dedicated to promoting the exchange of indoor environmental information through education and research. Learn more at IAQA.org. And RIA, the Restoration Industry Association, the granddaddy of the restoration industry. Network with leaders. Learn more at restorationindustry.org.
CIRI, Cleaning Industry Research Institute. See more deeply through science and research. Learn more at ciriscience.org. That's CIRI science.org. And before we turn it back to the Restoration Industries Global Watchdog, I just want to mention the CIRI conferences next week at Miami University of Ohio, and hopefully we'll see a bunch of listeners there. Pete, let's get over to you. I'd like to get you to weigh in and kind of start this second half.
Okay, thanks, Joe. One of the things is, I guess the second half, we prepared some questions. We want to get into the red meat, and I'm hoping that our InstaChat log doesn't start blowing up over here. We got the 20, 25 listeners. A couple things I want to say. One of the things that we did with the town hall that I found out is I asked when I opened the town hall at 6 o'clock, has anyone ever been to a town hall, know what a town hall was? And I think I got one hand in the whole audience. So I explained a little bit about the history of a town hall, what it was about. I'm not going to get into all that now, but essentially, it dates back to the founding of the country, but it's used mostly today in the political arena, and, we're in that season. But, the association's been doing town halls for years. A lot of the big national networks have them annually. So one of the things that we had to do, since it's such a hot topic, is we basically prepared an antitrust statement with some general guidelines and rules, and everyone had to sign one before they came in, and then I reviewed it. And that was really, really important. Anyone that belongs to an association and goes to any of these certification courses in schools, there's all kinds of things like that which are, apply. But people are not used to having to sign in them. We felt it was important. We wanted people to be real clear what the rules when they came in. And basically everybody, I think handled that well. You'll also see we have quite a few. We had a lot of handwritten questions, a whole bunch of them. One of the things that I'm going to do with one of the ladies in Harvey's firm, we're going to scan those in, and she's going to transcribe them. And one of the important things is we kind of know what's on the mind and the types of questions that were being asked. There was a wide variety of questions, a little bit of overlap. So anyway, just to give you a little bit of insight into that. So now we're going to continue to go around the horn in this order. Harvey, you'll be up first. John Faith, make sure you've got all these guys off mute. So we're going to be Harvey up first. Then we're going to have David, Mr. Crosa, and then Lapotaire. So Harvey, here's my question for you. I want you to tell the listeners, what kind of options do you feel that the town hall audience last night? Talk about some of the protocols, some of the recommendations that you gave out from your perspective in dealing, in this the post AOB era. Really, it's kind of the absence of the fee shifting statute. And anyway, don't take as long as you did last night, Harvey, but give us the Cliff Note version. Go ahead and share that, because some of those key talking points I'll put in the blog. So Harvey, you're up.
Okay. So basically, the fee shifting statute still, is in full effect for homeowners. So basically, a better way or a new way of doing this, that you don't need to comply with that new AOB law. You just don't use an AOB. And then what happens is you need to work with a public adjuster or an attorney that will help you get paid. But the attorney represents the homeowner directly. So essentially, we would put together the entire claim, write up the reports, make a demand on the insurance policy, and if the insurance company doesn't pay, then the fee shifting statute comes into effect. So it doesn't come into effect in any kind of settlement negotiations, and that's why we would charge a percentage just like public adjusters do. But what would happen with us is if it gets into litigation, whatever attorney's fees we recover from the insurance company goes back to credit the homeowner. So there'll be many circumstances where the homeowner doesn't pay us a penny. We get all of our money from the insurance company.
Harvey, let me get a follow-up in on that. I remember hearing that last night, and I was wondering, are you suggesting that a restoration contractor do this on every job, or just certain ones where they maybe know that the company they're working with has a history of maybe being a little difficult in paying the full bill, or are you thinking this should be done on every job?
Well, I mean, we'd be happy to be involved in every job or talk to people to give them advice. You know, every job isn't going to really work out for us. You know, the smaller jobs, I told people, just see if you can do a cash job, and, you know, they can put it on their credit card. If they submit their bill to the insurance company should reimburse the homeowner 100% minus their deductible. And if they don't do that, then we can help the homeowner so they don't have to bring us in up front. We can help them later. But, you know, I don't know what's going to happen. I can tell you that even when people, you know, use the AOB, insurance companies tend to, you know, short pay, underpay, slow pay, all that kind of stuff, you know, constantly. And that was with an AOB. So you can imagine you have absolutely no power with the insurance company without an AOB. I told people last night they can.
Hey, Harvey, Joe, let me take it back here for a minute.
Go ahead, Pete.
One of the questions that came up here in the chat is want to know what the attorneys, the typical fees are. We're not going to talk about that publicly because basically it'll violate price fixing and get into the violation of the antitrust. But the comment that I want to make is that, and this kind of lends to some of the stuff that John Lapotaire talked about, is contractors that let's say they were using the AOB, not using the AOB, but if they were familiar and it was part of their protocol to work with attorneys, work with public adjusters, they'll probably continue to do that. That was their business model. The ones that weren't, let's say they were using the AOB because they felt they need to use it to get paid in Florida, and there were many who may or may not work with an attorney or a public adjuster. Now they're going to work with people like Popper and Justin. And, you know, guys like that have been working with Ed Cross and many other attorneys around the country to get the proper contacts, make sure they comply with the local statutes. Okay. So I think that's is still going to continue to happen. And the fees that public adjusters charge or attorneys charge, they are what they are and they vary. So, I mean, we don't need to talk specifically, but just there is a fee. I think the key point that Harvey made is since the fee shifting statute still applies for homeowners, not in the contractor's case, there may be cases where they can actually collect the fees and the homeowner doesn't pay anything, and that's just depending on the loss and what the situation was. I mean, isn't that the main point you're trying to make there, Harvey, in that regard?
We can do that price for them. I mean, it's a couple of dollars less than what.
Yeah, who's that? Who's talking in the background there? I'm not really sure.
I'm sorry. That's me.
Yeah. So, I mean, anyway, Harvey, I think did you hear it? The last thing I said was, I think that was the point that you were trying to make, is that in some cases, the use of the AOB and the fee shifting statute will continue, but only working directly with a homeowner. And in many cases, if the funds are collected, then they won't cost them anything. If not, if there's a negotiation, there's a negotiation, correct?
No, I think basically, if you use the AOB, you're putting yourself in jeopardy. So
I'm not talking about contractors, Harvey. I'm talking about the homeowners.
Yeah, well, the homeowners don't need an AOB.
Oh, they don't need. Okay, then it's a moot point. Then that's fine. But the fee shifting statute still applies.
Yeah, definitely. Yeah.
Right. Okay. I got that. Okay. All right. Thanks. Thank you, Harvey. Joe, I'll move on to the next question.
Sure. Let's go over to David. You had asked everyone to come. Go ahead.
I was going to move to David now.
Go ahead.
Yeah. All right, David. So listen, you and Justin, obviously weighed in last night. You created this nice document, which we'll share with the listeners as part of the blog. Why don't you kind of address and talk about what the key talking points were that you gave last night? Some of them you talked about in the first part of the show, but why don't you finish weighing in, dovetailing off of Harvey and, talking to the contractors out there, and even we got quite a few, even on the line, we have quite a few assessor types, and certainly the people who follow the blog and who download the podcast. There'll be a pretty good mix between both remediators and assessors. So why don't you give them some pointers and advice of where you think it's going to go?
I think it's going to be like, there's a point where you just can't make this stuff up. What kind of issues will come up? We'll be surprised to a large extent. Courts, though, I can tell you, courts tend to read into statutes most of the time something that's fair, even if it isn't in the statute. And so I think I think it'll be bloody for a while. I think there'll be a lot of decisions, and we really don't know where they're going to go. So again, you can't. I'm a firm believer in controlling what I can control, and what I can control is my communication. What I can control is my integrity. What I can control is the client relationships, and what I can control is doing things right. And what I can control is a tight contract that is easy to understand for both the homeowner, you, and a court if needed. And again, you can't worry about what you can't control. Just stick to your knitting. Stick to your knitting like you've done. And I think that's the best thing you can possibly do. I wish there was more to it than that, but there really isn't.
That's well said. Pete?
Well, and David, I can tell your age as a baby boomer now, because when you use that expression, stick to your knitting, that's something that Tom Peters years ago used in the Pursuit of Excellence. And Jim Collins and all his Good to Great work talked about that a lot of these companies, they stick to what they're good at. So anyway, that was good advice. 35
in my mind.
Yeah, right. All right, Mr. Crosa there. You still got that cigar in your mouth there, buddy? I tell you, you look really you look like you're in a tropical paradise. Well, you do live in St. Pete by the beach, and you got that little sunshade hat on there. Listen, Peter, I think you really did a very good job last night. You were a real honest broker on a lot of the comments that you weighed in on. And, one of the things that you said, and it's something that really reacted to me, and I've heard you say it before, but a lot of people in the room probably haven't. You talked about that the insurance industry has bad actors too. And some of those bad actors in the past have probably maybe have been your clients, and you don't necessarily like working with them either. So, I mean, there's bad actors on both sides of the case. Why don't you talk a little bit and give some advice to the listeners on, what advice do you have as an independent adjuster, how they should deal if they get into a situation with an insurance company that has a policy they can't live with? What kind of advice do you have for the contractors and even an assessor if they're involved in some way?
Okay, well, when I heard we were going to be on video, I had to get the hat and the cigar for visual effect and emphasis. So I hope you appreciate it. Let me say this. I think that if you get into a situation where the adjuster is not playing ball with you and you sense any hostility that getting your money is going to be a difficult time, then that's when you have to draw back on all the advice that you got from your lawyers on how to secure a job, how to secure funding and payment, and how to get out of there with alive, basically, because a bad player, an adjuster can do you a lot of harm. There's a lot of passive aggression, and they are experts at passive aggression and just flip you up when things are the toughest. So you just better beware. My advice is avoid those companies. Somebody wrote to me and said, we've got some homeowners who are insured with a company that places very bad restrictions on them and doesn't let them choose a contractor. And then when we finish the job, we have a hard time getting paid. And my advice was, don't work for anybody who's insured with that insurance company. Just avoid them completely. Don't try to battle with them, because imagine if you're, David said, we're all in business. Yes, we're in business. If every case I had to sue somebody to get paid, that's not a business worth being in, to be honest.
Amen to that.
Yes,
yeah,
sir.
Thanks, Peter. All right, John, we're gonna move over to you now, and I might be repeating the obvious here, But it seems there was a little tension last night between you and Harvey. You guys had a different viewpoint on the AOB and whatnot. My personal opinion was that it probably was a misunderstanding. I mean, look, you and Harvey both live in Orlando. You go back, you've known each other for a long time. You've been on different cases together, sometimes on the same side, maybe sometimes on a different side. And I guess what I want to give you a chance to comment on is, do you think that either Harvey or the audience misunderstood some of your comments last night? And what is it that you really were trying to say and that you want to say, where your viewpoints differ on this AOB? Now's a chance to kind of set the record straight on that. So, Mr. Lapotaire, T-E-A-R. That's how they pronounce his name. He always does it phonetically. Lapotaire. Anyway, John, why don't you go ahead and weigh in and comment on that?
All right. So look, my opinion is very firm on AOB and always has been. And this is very specific to Florida. AOB has been around forever. Cliff and I talk about this often, and I'm not saying the AOB is bad. There's a time and a need for AOB. However, in the state of Florida, the AOB has been abused to the point of the litigation that just was introduced, the House bill. For it to get to that degree, it had to have been abused in a way that nobody's ever seen before, and that's what happened. The use of the AOB led to the increase in time and cost to restore, and then it was litigated with one-way attorney's fees. It was promoted and abused, and now it's changed, and we're going to have to figure out how the rest of us were able to do business successfully without extending the time and cost to restore and using an AOB. There's no magic in it. It's like David said, you just use a good contract, remember who your client is, and communicate with your client. I tell the people that we work with and the people that we train, we're consultants. An assessor is a consultant, and I consult on behalf of my client, the property owner, in setting the protocol and establishing everything that's going to happen and walking the homeowner, the restoration contractor, and the adjuster through it until we reach completion. We run into a change, we have an addendum. We write up the addendum, we photo document the addendum, we present the addendum to the homeowner, and then we present the addendum to the adjuster. We've never had a problem in all the years that I've been doing business with all of the contractors that we work with and all of the contractors and assessors that we train in getting paid. There are times the insurance company can be very difficult, but I can assure you your odds of getting paid skyrocket when you actually have a drawing log, when you actually have documented your loss. I agree that there are some bad insurance companies. I'm not saying that. I agree that there's a need for the AOB. But I don't think anybody in their right mind looking at the state and the condition of Florida can try and justify the AOB abuse that was going on. I'm involved in a lot of litigation with the AOB. No drawing logs, unbelievably overpriced work, whether it's the assessment side or the restoration side. Some people use the AOB in a time of need. Some people use the AOB on every single case. Day 31, we're litigating and we're shooting to get paid for every damn thing we put, every line item that we've added. And it's really shed a bad light on the entire industry. It was horrific for the entire industry to be painted to the same brush as the bad actors. Now, definitely not all attorneys that are using AOB are doing this, but it has led to bad restoration contractors, bad assessors, using bad practices to overcharge and hold people hostage with the AOB. There are still people that aren't whole from hurricanes from a couple of years ago because of AOB and litigation right next to condominium buildings that were fully restored and are fully reoccupied without an AOB. So for me, I don't think anything changes. I wanted to make it very clear in the town hall and today that this should not negatively impact, it should not in any way, any restoration contractor in the state of Florida. The amount of cases that should go to litigation should be very small. By and large, like Peter said, the vast majority will be settled and paid. There will be some working back and forth, but if you set the expectations up front, you maintain the communications with the homeowner, the property owner, and the adjuster, you will not have a problem.
Yeah.
Business will be as usual.
Okay, so John, Harvey, stand by. You'll get a chance to respond. Don't say anything yet. Look, was two follow-up deals. One follow-up, a question came up, Peter, right after Peter Crosa was talking, when you basically said the advice, if you got a bad insurance company and you know their policies are something that you can't work with from the contractor's perspective, you should don't work with those guys. Okay, right. But what about a homeowner? What advice do you have for the homeowner if they have a bad insurance company? I don't know. I might know the answer to this, but anyway, somebody put that up in the chat. I guess that's a good question. The contractor can say no, but the homeowner has a claim. How is that handled, and what position would that put you in as an adjuster?
This is exactly where you get Harvey. Harvey will represent the homeowners. That's exactly what he does.
Yeah. Well, that I already knew, David, but I was wondering from Crosa's standpoint as an independent adjuster, let's say he's assigned, how would he handle it, and what would you as an insurance adjuster tell the homeowner? That's what I was actually looking for.
Well, I have a lot of family members who ask me who's a good company to get insured with on their home or building. And in Florida, it's not a buyer's market. I mean, you really are hard pressed to find a good company. There are some down here. There's some excellent insurance companies that write high-end properties, and they bend over backwards to satisfy the policyholder, really. But most property owners in Florida are unfortunately insured with the available companies who are really substandard, and it is a non-service policy, and it's tough. So I tell my family members, well, try and go with so-and-so, try and get with this company, and they don't do it because people are very premium conscious, and that's their first focus. Well, I've got a cheap rate, but they don't know what's going to happen when they end up with a real claim.
Yeah, well, what I was going to suggest before we go to Roundup is if Harvey's got any comments on John, and then I figured we'd move to the Roundup.
Okay. Harvey?
Yeah, no, I don't have anything to say. John has his own opinion, and I disagree with it 100%. He does a lot of work for insurance companies, so he has that ideology. I don't work for any insurance companies, and I never would, and I have a different ideology. So that's it.
Yeah.
So listen, I have to clear this up. That's not true at all. I don't work for insurance companies. I work for property owners. That's a misconception.
Are you hired by insurance companies, John? John, are you hired by insurance companies?
Rare occasion. The litigation I'm involved with, I'm representing property owners or HOAs that are tied up in litigation over AOBs, and that's who I represent. I do not work or receive money from insurance companies. I work for property owners. That needs to be very clear. It's the property owner that is in need of help and being held hostage by the AOB. I'm not a henchman for the insurance companies. I don't want anybody to be led to believe that. My client will and always will be property owners. And when I go to litigation for property owners, it's to represent the best interest of the property owner and not an insurance company.
Yeah. Hey, Joe, it looks like we've already entered the Roundup. We're in the corral. So look, before we go to the Roundup, let me just say this. The whole point of a town hall is you have multiple viewpoints on a topic. All right? It's obvious that we knew ahead of time that Harvey and John have different viewpoints. That's okay. All right? We know David had a different angle on a lawyer, from a lawyer's perspective, than Harvey did. They agree on some things. It's not that they don't agree. It's just one is dealing with contractor law. The other one is dealing with, suing insurance companies. And then, of course, Crosa, he weighed in with his perspective, and I think it was a very honest broker of all the years of experience. And look, we didn't announce this, Joe, in his intro, but Peter wrote a book called How to Soft Sell Hardened Insurance Adjusters years ago. It was his original foray into the restoration industry. He's well known. He puts on workshops for restorers and travels around the country. And it's part of his business. His main business, obviously, being an insurance adjuster. And he tries to help contractors in that regard. And, and I think it's been fairly well received. So anyway, that's the whole point of doing this, is if you get a whole bunch of people who agree on something, then there's no debate. So let people have their say. And then at the end of the day, if you're being an honest broker to provide all the input from the different sides, then let the people in the audience, the customers, whoever they are, let them gather that data and let them make a sound decision based on the education, the information they had. And that's essentially what we tried to do. It's a contentious topic, we get it, but anyway, we did the best we could. And the people that were there last night, 50, 60 of them, I think a couple of the guys said, I think it was well received, and I think they enjoyed the information, the networking, anyway. So at that point, I'll turn it back to you, Joe, to go into the roundup, sir.
All right. Thank you, Pete. I think that was well said. Let's go once around the horn. Go ahead, John. All right, let's get some final thoughts. I just want to go around the horn, and maybe each of you can kind of give us your thoughts on where this is all headed down the road. I think David brought up a good point. There's still a lot to be litigated here. We're not sure which way the courts are going to go, but maybe you could give us your best prediction for where this will head, not just in Florida, but I think what's really important for a lot of our listeners is how is this going to affect the rest of the country? Let's start with David, and then we'll move on to Peter and John and finish up with Harvey.
Most judges, I've done this a while, most judges try to reach what they consider a fair decision. They'll sometimes even bend the statutes to get a fair resolution. There's some that won't. There's some that are very strict constructionists, and the law is the law, but most time they try to solve it. So again, the most important thing I can tell you is, let me tell you, I used to have a defense firm, and I used to represent some big companies like Ford and General Motors with a firm called Rumberger. And we'd always want to get I wanted to get an expert witness for something, whatever the issue was, and the company would balk. And I'd say, well, pretend we're in trial, and tomorrow we need that expert desperately. Would you write that check? He said, yes. I said, well, then write that check today. The analogy here is set up your paperwork and set up your communications as if it would go to court, so you have your ducks in a row, and then it won't. I find that every time I'm very, very prepared for a trial, it settles. Why? Because you can tell, you can read the body language, people know it. So have your contracts solid, have your communication solid. When you call them, follow up with an email. When people say you haven't talked to me and you got 25 emails that you can print down and a couple text messages and a solid contract, you're going to win that. Most times when contractors get in trouble, it's because it's not that they've done a bad job, they've not prepared to show they've done a good job. When I was in the Army, I was an Army JAG years ago. One general said excellence and the perception of evidence. Excellence and the appearance of excellence. So you got to do a good job, but you got to document it right. When you do that, you're going to come out fine 99% of the time.
Thank you, David. Much appreciated. And Justin, we'll come to you after I go to Peter, and just in case you had any final thoughts. Peter?
Well, something that came up yesterday in the town hall surprised me, and that Harvey said, and I actually thought it was quite brilliant. The insurance industry has the playing field. They have control of the playing field, seemingly, and they created new rules in this legislation. And so Harvey, I believe Harvey suggested, hey, don't take an AOB, because basically you're saying, we're not going to play by your rules. We're going to play by free market or common law practices. And I thought that was pretty brilliant. My advice to contractors getting involved with restoration is just try and work with your adjuster. Try and open up the lines of communication. Don't think he's gonna undermine you if you're open and above board. And don't clash with them. I think a good psychological strategy with adjusters is to express your concern about certain issues. Hey, I'm concerned that if we do this, we're not meeting standards that have been prescribed by the industry, rather than, you're an idiot. You're conflicting with the standards that are established in the industry. You'll get a lot farther that way, because adjusters can kill you with passive aggression. And basically, I'm addressing the 80% of the claims that can be settled without litigation.
All right. Thank you, Peter. Let's go to John Lapotaire, and then we'll go to Justin.
I think when I review, my experience in the last 8 to 10 years with contractors in the AOB and representing property owners, I think the one constant in the whole thing was the fact that the homeowners all reported feeling like they were dismissed from the case. They felt that they were literally in the dark about what was going on. And when they finally started realizing what was happening, it was out of control and it was far more intense than they anticipated. So the advice that you've received from the others up to this point is consistent with mine. Know your customer. You're there to restore the property on behalf of the property owner. Stick to that. Communicate with them often, daily, every other day, once a week. You've got to communicate with them. Let them know what you're doing and why, and then communicate that to the adjuster, and you guys will be just fine.
Thank you, John. Let's go back to Justin. Justin Peterman, did you have anything you wanted to add before we go?
I'll just quickly add that don't think that the sky is falling here. It's not. There's more, as the saying goes, there's more than one way to skin a cat. And, the important thing I think for contractors to realize is you need to get a plan together of what you're going to do. And that starts with getting with an attorney, getting with your adjusters, coming up with a plan of how things are going to get done, and especially getting yourself a good contract that if you're not going to operate under the new AOB law, getting yourself a good direct contract to work with the homeowners on. And just understand, you're going to have to, it's not that your business is going to stop, it's that you have to learn a new way to do the business. And so that's really what we're talking about here. And it's just a matter of learning some new tricks.
Thank you, Justin. I appreciate that. Let's finish up with Harvey Cohen. Harvey, final thoughts.
Thank you, first of all. Hello? Thank you for having all of us on. I think it was it's very helpful for everybody probably listening in and with the questions on the internet. The new AOB law in Florida is terrible. I can't recommend to any of my clients that they would use that. And the way that Florida goes, it seems like the rest of the country goes. But yeah, I agree with what Justin just said. It's not the end of the world. We just have to look at a different method. And, my whole motto, probably my whole life, is adapt and overcome. So that's what we'll do here. Thank you for having us.
And thank you all for joining us on IAQradio Plus today. I tell you, that was a fascinating one. A lot of comments, I think, it's great to have two sides and sometimes 3 or 4 different sides on a topic. And I want to also thank Pete Consigli for helping me pull this together. Pete, thanks again. Any final comments from you?
It's a contentious issue. There's been a bunch of us have been saying to watch Florida. Several years ago, I said I thought Florida was the new Wild West. In the late 80s and all throughout the 90s, it was Southern California that a lot of things coming out of there is what kind of directed their standards and policies and a lot of the development in the industry. And that was a big target region by the insurance carriers of the day. Now, of course, it's Florida is where the lobby was with the AOB, the fee shifting statute, and et cetera. And I think it's true. What's happening here has national and global impact because insurance companies and carriers, they talk, they share best practices. Sometimes the lobbies, they want to do test markets or whatever the particular case would be. And I think that the jury's still out. We have to see what's going to happen. Things will be tested in the court, but at the end of the day, I guess what I'd close with is this, and probably the most important lesson that myself and a lot of others learned over the years from Marty King, who's kind of founding father and founded the restoration division really of RAA. He basically always said, look, if you do 3 things, he said, do a quality job, be ethical in your dealings, but be fair in your dealings. And fair and ethical are two different things. And if you're just an honest broker and you're fair, open, you have good communication like they've been saying, that's not only going to benefit the insurance company, it'll benefit the homeowner, and it'll benefit the contractor, the restoration triangle, the three main parties to a claim. And, and the other thing I think is probably the most critical that he passed on in the last handful of articles before he retired several years ago. He felt that the most important aspect for the successful contractors are the ones that understood how to deliver the jobs on time, on budget, and satisfy customers. In other words, they were good project managers, and they're just good risk managers. So oftentimes the industry, they put a lot of effort in getting all the latest technology and gadgets, and some of them are really good marketers. Said those are important things in the business, but said neither one alone or together will assure the success of a good restoration contractor. He said you have to basically be fair with people, be honest, do good work, and you have to be a good project manager and know how to deliver those projects so you can make a profit, you can compete in the marketplace, and essentially satisfy your customers. And we have multiple customers in this business, although the primary one is the one who signs a contract, which should be the homeowner. And anyway, I guess that's what I would close.
All right. Well, thanks, Pete, for helping with co-hosting duties this week. Cliff will be back with us next week. I also want to thank this week's guests, Harvey Cohen, Peter Crosa, John Lapotaire, David Popper, and Justin Peterson. This is Radio Joe Hughes. Also want to bring in, thank John. You got to have faith at the controls. Most importantly, our growing group of loyal listeners. We'll be back next Friday for the next episode of IAQ Radio Plus.
For IAQ Radio, I'm Spike Reel saying thanks for listening.